I, as a person, I'm still trying to understand the judgment that was given yesterday by the tribunal judges, particularly what this particular justice said.
At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agree that they had agents in the polling units? I had thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building block of election results.
Now, this statement is confusing to me because we were all here when Peter Obi stormed the tribunal with several containers of evidence. Except the justice want to say to Nigerians that what we saw is not what we saw, then it will mean that the justice actually lied. Is the justice trying to tell Nigerians that the evidence that Peter Obi and the Labour Party, not even counting or mentioning the PDP now or Atiku, the evidence that they presented in the court did not contain polling unit results? Is that what he's trying to say? If this were to be true, does it mean that the evidence that Peter Obi submitted in court that we all saw, that was brought in batches, does it mean that those evidence were not polling unit results? Nigerians deserve to know. Because you see, I said it before and I'll say it again. Of all the grounds that Peter Obi based his petition on, and even Atiku, the only ground that is not subject to the prerogative of the justices or the judges was the one of the polling unit results. I did a video on it earlier. That is the result, that is the path that we should follow. And at the time, we were told and we saw that the legal team of Peter Obi knew what they were doing. And to corroborate that, we saw the evidence that was presented in court. Even though we cannot categorically say that those evidence contained polling unit results. But we saw the evidence. Now, if we look at both parties, looking at the justices now and looking at the legal team presentation of Peter Obi at the court, then one can not but ask the question, what happened to our evidence? Did the justice not go through our evidence? If the justice is making this categorical statement, then the onus is on the Peter Obi legal team to come clean. Because right now, it is not a case of the matter is still in court, it is sub judice. No. The matter has been dispensed of by the tribunal. And pending when an appeal will be filed at the Supreme Court, it is not sub judice to deal with this matter anymore. So if the justice of the tribunal, of the Court of Appeal, comes and make a categorical statement on air and says that both the petitioners, Labour Party and Peter Obi, Atiku and PDP, did not submit polling unit results to prove their case, then we must now come out to present the same polling unit results to Nigerians. These documents can be in the public domain. It is no longer a case of, oh, we will expose our evidence and then the Tinubu legal team will use it against us. No. We must now present in fact, this is the time now where the Labour Party should present their own collation or their own collated result. It is not a crime. I said it before, I'll say it again. It is not a crime for political parties to have their situation room, to have their own collated results. It is not a crime. Now, if we did not do this in real time, we can still do it subsequently. Now that the justice of the tribunal, the Elections Petitions Tribunal, has come to accuse, to make a categorical statement that neither Peter Obi and Labour Party or Atiku Abubakar and PDP submitted polling unit results, then the onus is on us to present it and prove them wrong. Because if we do not present these documents, then the general public will be led to believe that it is the Labour Party that did not submit polling unit result. And in any case, if this matter is going to go to the Supreme Court, then we must have our own collated result that proves that Peter Obi is the candidate with the majority lawful votes. This is the surest path. Even as the justice has said, even as other persons have said before now, even as we have said before now, this is the surest path. There will be no need. It will be a waste of time. It will be a waste of energy to go to the Supreme Court without this duly collated result of the Labour Party situation room, even if it was not done in real time. This is the time to now present that to the public. This is the time for the public to see it. This is the time to show all the copies of the polling unit results that we have. This is the time to show it. We cannot let these people get away with this. I said it before, the judges have their own prerogative. We can interpret these laws, 25% of the FCT, double nomination, disqualification due to the case, the drugs case. We can interpret it based on our understanding of the Constitution. But then the onus, the prerogative still rests on the justices or the judges of the tribunal. The only thing that does not rest on the prerogative of the judges or the tribunal justices is the polling unit result. It's the polling unit result. Look, the judgment yesterday was appalling. The fact that the justices gave the judgment that they gave showed to me that the executive, the legislature, and now the judiciary, or maybe let's not even add the judiciary yet because the Supreme Court is still there, do not care about the rule of law. That's what it suggests to me. So if we have to take them by the words and prove that the judgment they gave was not fair, was not just, then the responsibility is on us to present this evidence. I don't see why at this moment we should not have our own collated result as evidence. It is not a crime. It is not against the Electoral Act for you to put the document, your own collation, in the public domain, for you to have copies of the polling unit results. The case of Lagos that was made, do we have the polling unit results of all the polling units in Lagos to corroborate the fact that Labour Party got over 950,000 votes? If we do, like it is claimed, then we should provide those 950,000 polling units result and use it to collate our own result and present it at the Supreme Court. We need to do our own hard work. We cannot expect that the enemy will give us the ammunition that we will use to defeat them. We cannot. So we need to do this. If not, they will rubbish us like they have. Look at the way the justices just rubbished our case. It is one thing to do a show, like some people call it a show. In fact, I met a politician who said he's not interested in listening to the reading of the judgment, that it was all a show. And I said, well, if it's a show, then at least like Hollywood does their show, they do it to be realistic, to be believable. But the show yesterday was not even believable. Look at all the excuses that were made for the Electoral Act. The fact that INEC did not stick to its regulation. The fact that INEC did not stick to the electoral guidelines. Look at the explanation that the justices gave. It's painful. But then again, that falls within their prerogative to interpret. We know, you and I know, that that section simply meant that, okay, so from what the justices did, from the judgment that was given, it meant that there was no need for the Electoral Act 2022. There was no need for it. Because what the Electoral Act 2022 sought to resolve, sought to correct, is what the court, the tribunal, just said was not necessary. And what was that? The fact that ballot paper were being snatched from polling units, between polling units and collation center. That was what the Electoral Act 2022 wanted to correct. But from what the justices have done now, it means that anybody can snatch ballot boxes, anybody can snatch polling unit results from the polling unit, alter it like we have seen them altered. That's what it means. TPEX, the one you can TPEX, change the figure that you can change, take it to the registration area collation center, and if the INEC collation officer at that RA level does not have the IREV version to compare with to determine original, then it means that the forged one becomes authentic. That's what the tribunal just did. And it's a shame. It is a shame that in 2023, we are still talking about elections this way. It is a big shame. This is a gang up against Nigeria. And we must not sit idly by and watch them get away with it. The people who are behind this, they are not more than 20,000. So what will 200 million of us do? The people who are behind, they are not more than 20,000. So we have to do something. And part of the stuff that we have to do is we have to present our own collated results. We have to present our own polling unit result. This is the only way to prove it beyond the prerogative of the justices. Anything short of this, it's a joke that we have seen now. I'm not interested in grumbling and complaining. I am interested in getting results. And that is why I am saying at this point that the Labour Party must present the polling unit results, must present their own situation room collated result that shows that Peter Obi actually won the lawful vote. This is the only way to defeat the enemies of Nigeria. Anything short of this will be total waste of time. I've said it before, I'll say it again. The problems of Nigeria, they are coming from areas, directions that many Nigerians do not know. And that is why for us to understand what the real problem of Nigeria is, it is important that we follow the money. So I encourage you to join us as much as we can on a daily basis as we follow the money to reveal the problems of Nigeria so that we can solve them together.